Diaz-Catu vs. Rellosa, AC. Number 5738, February 19, 2008. Facts: Complainant Wilfredo M. Catu is a co-owner of a lot and the building erected thereon located at 959 San Andres Street, Malate, Manila. His mother and brother, Regina Catu and Antonio Catu, contested the possession of Elizabeth C. Diaz-Catu and Antonio Pastor of one of the units in the building. The latter ignored demands for them to vacate the premises. Thus, a complaint was initiated against them in the Lupong Tagapamayapa of Barangay 723, Zone 79 of the 5th District of Manila where the parties reside. Respondent, as punong Barangay of Barangay 723, summoned the parties to conciliation meetings. When the parties failed to arrive at an amicable settlement, Respondent issued a certification for the filing of the appropriate action in court. Thereafter, Regina and Antonio filed a complaint for ejectment against Elizabeth and Pastor in the Metropolitan Trial Court of Manila, Branch 11. Respondent entered his appearance as counsel for the defendants in that case. Because of this, complainant filed the instant administrative complaint, claiming that Respondent committed an act of impropriety as a lawyer and as a public officer when he stood as counsel for the defendants despite the fact that he presided over the conciliation proceedings between the litigants as punong Barangay. In his defense, Respondent claimed that one of his duties as punong Barangay was to hear complaints referred to the Barangay's Lupong Tagapamayapa. As such, he heard the complaint of Regina and Antonio against Elizabeth and Pastor. As head of the Lupon, he performed his task with utmost objectivity, without bias or partiality towards any of the parties. The parties, however, were not able to amicably settle their dispute and Regina and Antonio filed the ejectment case. It was then that Elizabeth sought his legal assistance. He acceded to her request. He handled her case for free because she was financially distressed and he wanted to prevent the commission of a patent injustice against her. According to the IBPCBD, Respondent admitted that, as punong Barangay, he presided over the conciliation proceedings and heard the complaint of Regina and Antonio against Elizabeth and Pastor. Subsequently, however, he represented Elizabeth and Pastor in the ejectment case filed against them by Regina and Antonio. In the course thereof, he prepared and signed pleadings including the answer with counterclaim, pre-trial brief, position paper and notice of appeal. By so doing, Respondent violated Rule 6.03 of the Code of Professional Responsibility. Furthermore, as an elective official, Respondent contravened the prohibition under Section 7b, 2, of R. 6713. Issue: whether herein Respondent violates Code of Professional Responsibility. Held: yes, but the Respondent cannot be found liable for violation of Rule 6.03 of the Code of Professional Responsibility. As worded, that rule applies only to a lawyer who has left government service and in connection with any matter in which he intervened while in said service. Section 90 of R. 7160, not Section 7b, 2, of R. 6713, governs the practice of profession of elective local government officials. Section 7b, 2, of R. 6713 prohibits public officials and employees, during their incumbency, from engaging in the private practice of their profession unless authorized by the Constitution or law, provided that such practice will not conflict or tend to conflict with their official functions. This is the general law which applies to all public officials and employees. For elective local government officials, Section 90 of R. 7160 governs. Section 90. Practice of profession. A. All governors, city and municipal mayors are prohibited from practicing their profession or engaging in any occupation other than the exercise of their functions as local chief executives. B. Sanguinian members may practice their professions, engage in any occupation, or teach in schools except during session hours, provided that Sanguinian members who are members of the bar shall not 1. appear as counsel before any court in any civil case wherein a local government unit or any office, agency, or instrumentality of the government is the adverse party. 2. Appear as counsel in any criminal case wherein an officer or employee of the national or local government is accused of an offense committed in relation to his office. 3. Collect any fee for their appearance in administrative proceedings involving the local government unit of which he is an official, and 4. Use property and personnel of the government except when the Sangguniang member concerned is defending the interest of the government. This is a special provision that applies specifically to the practice of profession by elective local officials. As a special law with a definite scope, that is, the practice of profession by elective local officials, it constitutes an exception to Section 7b, 2, of RA 6713, the general law on engaging in the private practice of profession by public officials and employees. Lex Specialibus derogat generalibus. While, as already discussed, certain local elective officials, like governors, mayors, provincial board members and councillors are expressly subjected to a total or partial prescription to practice their profession or engage in any occupation, no such interdiction is made on the punong barangay and the members of the Sangguniang barangay. Expressio unis estate exclusio alterius. Since they are excluded from any prohibition, the presumption is that they are allowed to practice their profession. And this stands to reason because they are not mandated to serve full time. In fact, the Sangguniang barangay is supposed to hold regular sessions only twice a month. Accordingly, as punong barangay, Respondent was not forbidden to practice his profession. However, he should have procured prior permission or authorization from the head of his department, as required by civil service regulations. As punong barangay, Respondent should have therefore obtained the prior written permission of the Secretary of Interior and Local Government before he entered his appearance as counsel for Elizabeth and Pastor. This he failed to do. The failure of Respondent to comply with Section 12, Rule 18 of the Revised Civil Service Rules constitutes a violation of his oath as a lawyer, to obey the laws. Lawyers are servants of the law, vires legis, men of the law. Their paramount duty to society is to obey the law and promote respect for it. To underscore the primacy and importance of this duty, it is enshrined as the first canon of the Code of Professional Responsibility. In acting as counsel for a party without first securing the required written permission, Respondent not only engaged in the unauthorized practice of law but also violated civil service rules, which is a breach of Rule 1.01 of the Code of Professional Responsibility.